standing in front of the Capitol building in Albany, the seat of government for the state of New York. At the 1787 Constitutional Convention in Philadelphia, many compromises were discussed about what to do with states' powers versus the powers of the federal government. It was pretty much decided to set aside a set of ideas that the states could handle on their own, and this soon became the 10th Amendment to the Bill of Rights. In this amendment, it was decided that reserved or residual powers by the states would include things like marriages, divorces, and later on things like driver's licenses. The federal government, however, would have things it could specifically do. These powers were called delegated powers. Together, each of these two branches, the federal and the states, could have concurrent or powers given to them to do at the same time. An example would be the power to tax. Another would be maintaining highways and roads. Another level of government that we're going to be looking at is the level of city government. Behind me is the Albany City Hall. In the Albany City Hall, you would register births and deaths, and you would actually apply for your marriage license. This would take some of the responsibility away from the state governments, which would be bogged down with this kind of day-to-day tedious business. Federalism, then, is this concept of division of powers. The federal government can do some things that states cannot do. States can do some things that cities cannot do. Cities can do things that towns and villages and hamlets cannot do. This, then, is one of the major compromises at the Constitutional Convention, the theme of federalism. I'm standing in front of the New York State Court of Appeals. In our state, this is the highest court. Unlike in the federal government, where the Supreme Court is the highest court in the land. One of the things they have in common, however, is the right of judicial review. Both courts can look at laws to determine whether they violate their constitutions or not. On the state level, the state constitution, and on the federal level, the federal constitution. This concept of judicial review was begun by John Marshall, the fourth Chief Justice of the Supreme Court. He took a look at the Judiciary Act of 1789 in a famous case called Marbury versus Madison. In 1789, the Congress of the United States had decided to regulate the jurisdiction of all federal courts, and in the Judiciary Act of 1789, Congress established with great particularity a limited jurisdiction for the district and circuit courts. They also gave the Supreme Court original jurisdiction, which they believed had been provided for in the Constitution, and granted the court appellate jurisdiction in cases from the federal circuit courts and from the state courts where those courts' rulings had rejected federal claims. The decision to grant federal courts a jurisdiction more restrictive than that allowed by the Constitution represented a recognition by the Congress that the people of the United States would not find a full-blown federal court system palatable at that time. In 1800, Thomas Jefferson had been elected President of the United States after 35 rounds of votes in the House of Representatives. He had tied Aaron Burr, and the Constitution had made no provisions for a tie. This meant the House had to decide who the president would be. After that first crisis had passed, President Jefferson then had to deal with President Adams' appointments of what were known as the Midnight Judges. Literally on the stroke of midnight, President Adams had signed a bill creating jobs for a number of people who would now have to work for President Jefferson. Not wanting all of these Adams appointees, the president instructed his Secretary of State, James Madison, not to deliver some of the appointments. One of these people who was waiting to become a judge was named Marbury. When Marbury was denied this job he had been promised by President Adams, he attempted to take his case to the Supreme Court. The problem was that this case had never been heard by any other court. Therefore, this was going to involve the original jurisdiction in the case. The Supreme Court was really only supposed to deal with appellate jurisdiction. In other words, on cases that had already been heard, and some appeal based on constitutionality was now going to refer it to the Supreme Court. All of this notwithstanding, Marbury was told originally by the court that he could have his job, and then upon consideration or reconsideration, the court decided under John Marshall that the Judiciary Act itself was unconstitutional, that it did not have the power to allow the Supreme Court to determine original jurisdiction. It could only hear cases involving appeals. In this particular case, the Chief Justice decided that the law indeed from 1789 was unconstitutional and therefore should be found null and void. In declaring it null and void, he established once and forever this idea of judicial review.